Okay. Looks like we've got enough people come through to join us now, so we can make a start. So if you've just joined us, my name's Mark Stewart, and welcome to today's webinar, Defending Your Business, Navigating the Surge in Unfair and Opportunistic Claims. Before we dive into the presentation, we'll just cover off a couple of general housekeeping rules. If you have a question during the webinar, there's a chat function. You don't need to use that. There is a Q&A feature at the bottom of your screen. If you click that, you'll be able to pop anything in there. And then at the end of today's presentation, we'll come back to these and aim to answer as many as possible. We don't usually get through all of them, just so you're aware. We do have, people are pretty interactive in these things. We'll try and answer what we can. Anything that we don't get to, we can follow up with you after today's session as well. There's no need to wait until the end to ask these questions. You can just type them as we go. Today's webinar is being recorded, so for those of you that would like access to the recording, a link will be made available after the session has ended. So our webinar will be presented today by Ian Smith, who's the Director of Advisory at Citation HR and Safety. Ian brings over 3 decades of experience as a lawyer and executive, advising businesses on complex workplace relations matters, including unfair dismissal, general protections claims, investigations, and performance management. Through his work at Citation Group, Ian supports organisations to put practical, defensible processes in place, helping businesses not only manage claims when they arise, but reduce risk by getting the fundamentals right from the start. Ian, we're thrilled to have you here presenting today and sharing your expertise with us. If you haven't attended one of our webinars in the past, we'll just give you a little bit of info on Citation Group. We've been around for about 30 years now, just over 30 years, working to help Aussie and Kiwi businesses by providing complete workplace compliance solutions that help create better workplaces. So whether you need help with HR, workplace safety, legal compliance, ISO certification, or specialist advisory services, Citation Group provide expert guidance, practical tools, and tailored solutions. So with decades of experience and a commitment to excellence, our team helps businesses like yours stay compliant, safe, and ahead of the curve. So today we'll be featuring Citation HR. So Citation HR is a complete, compliant, and cost-effective solution that helps your business keep on top of HR obligations, streamline people management processes, save you endless hours, and of course, money. So whether you're a small business or a large enterprise, every company needs a solid HR partner who supports and also provides that reassurance to you guys. So one of the great things about Citation HR is we can provide tailored HR solutions to your business. So we've got a 24/7 HR advisory line where you can access our workplace consultants. We have HR software and a library of HR resources. We've got the Advice Promise, and we've even built our own compliance training center. So there's a wide range of solutions that will likely fit your needs. If you'd like to learn more about this, I'd be more than happy to speak to you after today's webinar so we can work together on a bespoke solution for your organization. Right, so that's about it from me for now. I'm going to hand over to Ian for today's presentation. I hope you enjoy the webinar and you'll see me a little bit later on just to finish things off here. Ian, over to you.
Thanks very much, Mark, and good afternoon, everyone, and thanks for joining this presentation. Over the next short time together, I'm going to try to give you some context on the framework which permits what we've called for the purposes of this presentation, opportunistic claims. What do we mean by opportunistic claims? Well, I guess we're really talking about an environment where it's relatively easy for an employee who feels wronged, whether that's through termination or through some other process, to bring a claim against their employer. A claim probably that sometimes isn't very meritorious, so it doesn't really have much legs, but because it's relatively easy to commence these proceedings, they're used as a tool or a strategy to try and milk the employer for more money. Again, some of them are very legitimate, and that's perfectly fine, and that's what the system exists for. But there are some which we would refer to as more opportunistic. And so we want to understand why claims are surging, see where small to medium enterprises are most exposed. And most importantly, I'm really wanting to try to give you some tips on actions which will protect your business and your people ultimately. So I want this presentation to be informative and practical, not theoretical. It'd be very easy for me to go into the theoretical because I find it really interesting, but I want it to be really practical. There are things that you can do to help yourself or your businesses when the claim hits your email. And statistically, and unfortunately, that might just be likely. You aren't powerless in this process. They may be opportunistic claims, but there are ways that you can defend yourself. And really, a good dose of prevention is much better than hoping for a cure. And I'm hoping to leave you with a way of thinking about approaches to termination and potential claims risks that reduces stress and cost for you. It is a really stressful process, can be a really stressful process. It's not easy. There's a lot of uncertainty, but there are things you can do to give yourself a really strong foundation in the event that a claim comes across your desk. So when I talk about cost as well, cost here isn't actually about the dollars, though it can be quite expensive in terms of what you ultimately need to pay. It's cost in terms of time, in terms of stress, and also obviously in terms of reputation. And that, again, necessarily is not about your brand reputation out in the market, but it's your internal reputation as to how you deal with staff. These things are all highly relevant as to how you should defend yourself and how you should approach these sorts of discussions with employees who perhaps aren't performing. Always keeping in mind that the next stage might be a claim against you. So if I had a tagline for how to approach defending your business, it would be this: fairness you can prove. So the best way to defend yourself in these scenarios is by showing and being able to evidence that you've been really, really fair throughout the process. And there's a key word there, evidence. It's not enough to say, well, we had a chat and we told the person this and we asked them to improve and then they didn't improve. You've got to show that actually happened. You've got to show that this person, the employee, it was made clear to them exactly what had occurred, why there was a need to improve, all of those things. And you need to be able to show that those things happened, whether that's through confirming an email with the employee, whether that's making a file note, etc. Those things are really, really important and give you a really strong foundation. Much easier said than done, and I accept that people are busy, people don't have time to do these things. But if you don't devote a bit of attention to doing it, you can be in for a world of hurt. So let's start with just a short story, a short intro, if you like. And obviously, names have been removed here to protect the innocent. But think of an example of a 12-employee manufacturing business who has a team member on a permanent contract, some permanent employment contract, and they've failed to turn up for work on several occasions. Not consistency in terms of a run of days, but just occasionally they fail to turn up. This employee always has an excuse after the fact, but is completely unremorseful. It stresses the boss. It leads to service levels dropping, and it causes resentment amongst the team generally. So you'd think it should be an easy termination, right? They're just not a good employee. Well, yes and no is the answer. Yes, in that there's, again, conduct that's fairly average in this process. But no, in this particular circumstance, in that the boss decided to terminate, didn't keep notes of discussions, dates, times and conversations, things like that. Let emotion rule. That they were just really annoyed with this employee. Didn't take advice or follow process necessarily, and ultimately chose to terminate the employee in the corridor after a stressful day. No notes, just you're fired. Thanks very much. So you understand that's obviously an extreme example, but it's not too far from the truth of some of the things that we deal with here at Citation and how we help people get through them. These things are really understandable as to how they play out in this way. A week later, unsurprisingly, an unfair dismissal application lands on the desk or in the email. The boss is frustrated. Why can't I just get rid of poor performance, he thinks, and why did I do something wrong? I've got a business to run. I just don't have time to follow all these niceties. Maybe some of those things sound familiar to you. All perfectly legitimate, but probably unhelpful in terms of what the purpose of this presentation is in defending your business. that that particular employer hadn't set himself up terribly well to be able to defend the claim that's ultimately coming, be able to prove that there was fairness, they would be able to prove that there was a good, legitimate reason as to why these conversations were happening, that to be able to prove that the employee had actually not been a good employee, as it turns out. So in a tight market with thin HR resourcing, informal is normal and completely understandable. But the Fair Work Commission, who governs these things, doesn't run on informal, unfortunately. It looks for a process, it looks for documentation, transparency, thought and fairness. Though, of course, fairness is less of an issue in the general protections claims, but it's still a good foundation for decision. So his approach was a bit of a disaster and hard to defend. Active management of this issue would have yielded better results. But I'll talk more about those approaches shortly. We could have the next slide, please. So why claims are surging. So we've called it a surge or said surging here, but it's actually more on a year-on-year increase with no obstacles to slow it down. I'll talk a bit more about that a bit later too. But so why now? Why is there this surge? Well, first, and to adopt a sort of an economics term, there are very low barriers to entry for a wronged employee. Now, in theory, and this is a personal view, I'll state that access to justice, so allowing people in the community to have their wrongs redressed in a simple and cost-effective way, is a really good thing for society in general. Access to justice in the courts, etc., is often costly, complex, confusing. I don't need to tell you that. But under the Fair Work Act, various amendments under the Fair Work Act and its various amendments, it's simpler and cheaper than ever to file an application for an employee. It's virtually no cost. And AI has been revolutionary in giving employees the ability to produce long, legal-sounding, polished claims for unfair dismissal or for a general protections claim. As a quick refresher, just as an aside, because we talk about unfair dismissal a lot, but general protections not so much, and so it may not be familiar for all of you. The general protections are laws designed to ensure that employees aren't treated adversely because they've exercised what we call a workplace right, engage in industrial activity, for example, or because or there are protected attributes, for example, like age, race, or disability. So they sit separately from this unfair dismissal, which we often talk about and which a lot of today's focus is on. They sit separately from unfair dismissal and focus on preventing harmful retaliatory conduct for prohibited reasons, whether or not someone has been dismissed or not. So it doesn't actually, you can bring a general protections claim, or an employee can bring a general protections claim, even if they're still employed, because they say they've exercised a workplace right, they've made a complaint, for example, and they're feeling that their employment's at risk as a result of it, or they're not being treated fairly as a result of it. That's generally unlawful, and people can bring actions for those things. So that's the first thing, very low barrier to entry. Second, economic pressure. When the job market's tight and when cost pressures are high, employees are more likely to challenge decisions, especially if the process felt abrupt or unclear. Equally, employers who may be feeling the pinch are less likely to merely put up with poor performers. They'll want to streamline and cost save whenever possible. Also, I think, and it is 2026, there's a greater awareness of the impact of poor performing or poorly behaving staff on the broader organisation, and there's an imperative for a lot of organisations. A lot of organisations see that there's an imperative to actively manage poor performers in this way. They can't just let them sit. They do need to do something about it. Thirdly, there are advocates and agents out there. So there are lawyers and advocates out there who have built businesses helping wronged employees. As the young people say, and I'm not throwing shade in the direction of those advocates and agents. It's perfectly legitimate business, but there are lots of people out there now who can help for a very low cost, help employees try and get what they want and potentially get a cut of ultimately what the settlement might be or what the outcome might be. Some advocates actively solicit claims and can package a narrative or a claim very, very quickly. So again, this is assisting and it aligns with this very low barrier to entry. So those factors combined with the Fair Work system, which is bulging with work, leads to delays and a pipeline of cases that are slow. Settlement of cases in these circumstances is almost irresistible because it's sometimes cheaper to pay, even though it's not fair, than to deal with the stress and the time and all of the other issues that come through when you're having to deal with or defend a claim. So, in defending your business, what's against you isn't a wholly legal problem, it's a structural one too. The system makes it easy to lodge and very hard to ignore. So in defending it, and we'll talk more about this, we counter it with habits and habits for your business as part of your everyday. Small, simple things we can do every time. Take notes, send invites when you're disciplining your staff or having to have discussions with them about their performance. Make sure that the responses are written. Make sure that there are outcome letters, so there's conclusions to discussions that are had, so that your fairness becomes really, really visible, and a bit more on this shortly. And it's just useful to remember that a single contested exit can cost more than a full year of basic HR training and manager refreshers for the team. It's sad but true that businesses either pay for habits up front or pay in hours, fees, and stress a whole lot later. The good news about the surge, though, that we're talking about is that it's not unrecognised as a significant issue. And last year at the Australian Labour and Employment Relations Association's conference, the Fair Work Commission President, Adam Hatcher, he said that there's been a 24% increase in matters over the last year. On the back of a record year prior to that as well. And this has been led generally by those general protections claims, which I mentioned earlier. He set out and said that 2/3 of GP claims are made by individuals who do not meet the qualifying period for unfair dismissals. What he means by that is you can't bring an unfair dismissal claim if you've been employed for less than 6 months. And if it's a small business of less than 15 people, an employee can't bring an unfair dismissal claim for less than 12 months, if you've been employed for less than 12 months. And it seems that some paid agents have developed a business model which involves treating general protections claims as a substitute for an unfair dismissal claim. So whilst you might not be able to bring an unfair dismissal claim in the first six months, you can bring a general protections claim. There's no bar to that. And again, the barriers to entry are very, very low. A rather startling statistic is that 4 out of every 5 general protections claims don't proceed to court if they're not settled at the Fair Work Commission. And just as a reminder, when you get one of these, whether it's an unfair dismissal or a general protections claim, apart from responding to the claim itself in writing, the very first step is a conciliation, where a member or a staff member of the Fair Work Commission gets you in a room, virtual room, and tries to get to resolve it so it doesn't go any further and it doesn't cost any more money. So, but it's, again, startling to say that 4 out of every 5 claims that are brought don't proceed to court, even if they don't settle at that conciliation process. So it really does show that it goes to this point about opportunistic claims. They really are opportunistic. They're just a mechanism to try and squeeze a bit more money out of an employer who has terminated somebody. So there's a real misalignment between intent and reality there. Employers can use the low barrier to entry process to have a crack at getting more money from the employer, knowing full well they won't actually commence proceedings if the first step conciliation doesn't receive a result. So looking at what's next, the Fair Work Commission is going to make things more efficient. It's also looking to avoid unmeritorious claims that drag employers into the system and require them to spend time and resources participating in claims which aren't going to succeed. So this includes new things. Will be requiring applicants to fill out new claim and response forms that will need more rigorous detail, if you like. Shifting to deciding whether to throw out an extension of time case on the papers, i.e. so no one has to make a submission about that. Putting parties on notice that conferences are to settle cases and they're not a substitute for hearings. So it's really about, can we settle it? It's not about arguing the merits of the case. And terminating conferences if one or both parties don't wish to settle. So, but we all need to watch this space in terms of those improvements. Next slide, please. So this perhaps it was the slide I should have been using for the last little section, but effectively low barriers, economic pressures, advocate activity, and fair work delays. These are the things that really are assisting in this surge. They're creating a huge headache for the Fair Work Commission because they have so much work to do, and a huge headache for all businesses, small, medium, and large, in terms of how to just continue with your day to day in terms when you're very, very busy, but you've got this threat. So every time you're needing to discipline an employee, every time you're needing to provide robust feedback to an employee, you've got this hanging over your head. And it's now, unfortunately, just a genuine cost of doing business in the same way as having to pay tax is, having to pay superannuation is, having to market to your clients. You have to have an eye to the fact that your employment relationships are going to be governed by and impacted by the ability of employees to take steps against you should you choose to take action against them. It's something you can't ignore. I don't want to overstate it, but it's an inevitability and it's a risk that you need to have an eye to. But there are ways you can manage that risk in a really with low effort, which will yield massive results ultimately. So next slide, thank you. So what the law really expects, in practice and on termination, businesses should pay attention to the following things. So, one, give a valid reason. The reason must connect to the conduct, the capacity, or the performance. So it's about having a conversation. You've got to be clear. You've got to be transparent. You've got to make the employee understand why you're having the conversation and why there's a consequence. It can't be just a conversation. It can't be like the example I used, which is obviously a bit trite at the beginning. You're fired. See you later. No explanation. That just doesn't fly. We're talking about fairness here. It's really, really important to keep that in mind. Is it a fair process? So procedural fairness, I've just mentioned that. The employee should know the concerns, have a genuine chance to respond and consider and even have a support person there if they need it in terms of those conversations. 3, documentation, really important in terms of evidence. Contemporaneous notes, and that's often a legally phrase, but all we mean by that is just take a note as you're in the room and finalise it immediately as you walk out of the room after you've had one of these discussions with your employees. And that's not just at the point where you're looking to terminate or you're looking to discipline or looking to give them a warning. It's really important to keep notes of the more intense discussions that you might have with your employees. So you've got a paper trail and you can show if there's a history of issues or a history of performance concerns, you've got a paper trail to say, well, I just did discuss that with them on this date and this is what we said and this is what we agreed. Is it an impost on your time? Absolutely. Does it save you ultimately? I can't stress how much it saves. It saves you. When I get a case come across my desk and I'm helping one of our clients with it, and I see that they've got file notes and I see that it's very clear when they've had a conversation with somebody, makes it so much easier to prove fairness. If they come to me and say, well, I've had all these conversations, but they're informal, we can still defend it, but it makes it a whole lot harder. And therefore, the stress is a lot higher for you guys as well. So procedural fairness, documentation, and then the small business code. So this is for small businesses, again, under 15 people. It's a genuine shield and it's a genuine way that the Fair Work Commission allows smaller businesses to just sort of have an easier route through being able to defend themselves. And so the code protects small businesses by giving them a clear, simplified pathway to follow when dismissing an employee, reducing the risk of an unfair dismissal claim for them. If the employer follows the code, the Fair Work Commission will generally deem the dismissal fair, providing an added layer of certainty for that business, obviously, and a defensibility for those businesses as well. But to do it, to avail themselves of this protection, the employer must give a valid reason, warn the employee, provide an opportunity to respond and reasonable chance to improve if necessary in the circumstances. Consider the response of the employee before deciding to dismiss. So you can't have a meeting and say, well, generally, you can't have a meeting and just simply say, well, I don't like your conduct. What have you got to say? I don't believe you. You're out the door. You can do that in some circumstances, but it's generally better if you can prove that you've actually considered and listened to what they've said. whether there are extenuating circumstances, etc. And then complete what is a small business fair dismissal code of conduct checklist. So there's a little checklist that you can fill out and submit with your form when you're defending this. So there's a bit of a red light bulb moment here. Is there were many cases that I've seen where where the employer thought they were fine, but they've just missed one step. They've done everything, but they've missed a step. And maybe that's the chance to respond, for example. It's often overlooked, giving the employee time to respond to the allegations that have been put to them. You miss that step, or you miss any of these steps that I've just talked about, and it makes it really, really difficult to defend, because potentially it's seen as unfair. And again, the focus is, basically on unfair dismissals, is on the fairness aspect. So next slide, please. So the approach. This is the practical part I was talking to you about, I mentioned in my introduction. So before, well, I should say overall, good documentation and timing remain the best protection. Notes of meetings, warnings, reasons for decisions that are written down and clearly articulated, they're going to be critical if a claim arises. So businesses need to constantly reinforce with either themselves, for small businesses, or with managers and decision makers, or that notes and communications with employees around reasons for termination are critical. And we can get into a whole other discussion around how to deal with employees, and that regular discussions are important, and regular feedback and positive feedback and negative feedback and constructive feedback is really important. And it sort of helps build your foundation if you are going to have difficult conversations with staff. It's a whole nother conversation, a whole nother presentation probably, but it doesn't hurt if you're having regular communications with your staff, and you can prove again that there's always been this opportunity for the staff member to talk. It's been a really fair process. But to what's in front of you on the slides there. So before, setting expectations and providing early coaching. What I mean by coaching then is coaching of the managers, is coaching of your leadership team as to what the expectations are in terms of how to deal with staff and how to follow a process if there is a performance issue before you with respect to a particular employee. So once you've identified that there is this poor performance and it does need to be remedied, conducting the meeting and gathering feedback, you need to send a clear invite. You need to hold a calm meeting. You remember in the first example, I said that you'd let emotion rule. Calmness and professionalism is incredibly important in these processes as well. It can be, if you're overly emotional, if you're overly angry, frustrated, express those things in the meeting. That can look like an unfair process. That can seem like you were taking an action because of your emotional state rather than because of the objective facts, and you've got to keep it to the objective facts. So hold a calm meeting, listen, capture the employee's response. What I mean by capture is take a note about it, take a break, consider, make decisions. So again, you want to be able to prove that you've listened to what the employee has said. Then afterwards, you've made the decision that the employment's been terminated for whatever reason. You've got to issue an outcome letter. You've got to make it clear as to why. You've got to keep that on the file. You've got to keep your file notes on your file. And it doesn't hurt in the circumstances, again, this is hard when everybody's very time poor, is to run a short retrospective or a post-mortem, you could call it. What did we learn from this? What would have made it smoother? Is there improvements we can be made to the way we communicated or how we did this? Doesn't hurt to just constantly try and learn and improve through this process as well. Because unfortunately, these circumstances, they don't just happen once in a career. They happen quite regularly as an employer. And I'm sure I don't need to tell you guys that. So paper beats opinion every time. The goal isn't red tape. And I'm not trying to get you to spend all your days behind a computer and making notes about employees. That's not the intention of this. But you need to do enough to be able to show that the process has been fair, that that fairness is visible to an outsider. So someone who doesn't know anything about it can look at it and go, yeah, I can see that there was an issue here with the employee, but I can see that it was dealt with really well because they did this, and then they did this. So they had the communication with the staff member. They gave them the feedback. It was a very calm meeting. They followed it up with an email which set out some expectations. There was a further discussion when the employee wasn't actually managing or improving, and led to the fact that the employee has a right to terminate in those circumstances when the employee isn't performing very well. So that's the approach. It looks pretty simple. It's hard to do in practice, particularly when everybody's very busy, but it's incredibly important. So next slide, please. So there's some case studies. I'll just run through. They're very short. So first one, case one. Imagine a cafe scenario. There's employees. One employee is chronically late. The manager's given them some warnings and said, look, you can't do this again. Don't do this again. You've done it again. Don't do it again. But these warnings have always been verbal because they're in the middle of making coffee or serving customers. Nothing's ever written down. It's very high risk to then be able to terminate that person without consequence. If you then sit down with them and say, I'm really sorry, but we're going to have to let you go, everything becomes contestable because the employee will have a very different recollection of the conversations, whether deliberately or otherwise. They will have a different recollection of it. And if you can't put in front of them to say, I spoke to you on this date and this is what we said and this is what we agreed and here it is written down, it's very, very hard to defend against that. So if it isn't written down, it's debatable. And people's recollections of these things do differ significantly. Case two was a retailer introduced short notes after each chat with their employee and had consistently gave invites and allowed them time to respond. There was a termination, a claim came, but the paper trail told a fair story. There was very little work to do because it was all there written down. You could just point to these various pieces of correspondence. So these tiny habits, and I've talked about this earlier, gives huge leverage in defending yourself. Case three, a health practice, used the small business code properly alongside a clean checklist. So they went through the small business checklist, ticked off every step that they needed to take. The result was the exit was defensible. When the claim came, they could just turn around to say to the commission, I followed the code, here's the checklist, this is what we did. There was minimal disruption thereby. It was a very, very defensible claim. So across all of those three examples, the theme is consistency, not perfection. No one's expecting perfection. It's the same small steps every time. And if there was one of them that I wanted you to do, it'd be around keeping notes of your discussions, keep file notes, be able to evidence exactly what occurred. And another way to think about it is think about how you would like to be treated in that scenario. Now, I'm sure none of you ever would need to be performance managed in that way, but think about, were you to be accused of or a suggestion made that you're not performing at a certain level, you'd want to have the opportunity to hear the reasons why or to be given examples of it. And you'd also want to be able to be given the opportunity to respond in an environment where you felt that you were okay to be able to respond to that. If you think about it that way, and you implement that in terms of your discussions with your employees when there are issues that arise, you're going to get a much better outcome. It's going to be far less stress, and it's going to be far more defensible. And then the last slide, I think. Thank you. So next best steps. Recognise areas where managers lack knowledge or support. So do an assessment when you're back at your desk or you're talking to your team next time or your management team. What areas are there where they lack knowledge or support? Is it around file notes? Is it around just the process of termination? Is it around understanding what a unfair dismissal claim is? Those things you can address, and if you can address them early, they're really, really helpful. Ensure easy access to essential documents like warning letters. Have you got precedents? You may not be a big enough business to be able to do that, but that's possibly somewhere where citation can help you. Motivate managers to take proactive steps rather than waiting. Interestingly, a manager's failure to properly manage an exit is actually a performance concern generally. So, yeah, in the same way as you're expecting them to treat their employees fairly, you've got to treat the managers fairly by setting expectations around what you want them to do. It's very difficult and not ideal to criticise a manager for failing to follow a process when they didn't know that the process was even there. So regularly update managers' skills and understanding. So revisit this on a regular basis. Talk about how your managers are managing their team, how they're being proactive in terms of making sure that the performance is good, the performance is right, that their teams are being supported, etc. And then look at checklists. Checklists are fantastic to ensure consistency and thoroughness. And again, that's something potentially that we can help you with here at Citation. And that was the messaging I wanted to give to you today around the surge in claims and how to defend yourself. Thanks, Mark.
Perfect. Ian, thank you. I think you've hit the nail on the head there. We have had a ton of questions, which we're going to get to shortly in the Q&A section. Again, apologies in advance if we don't get to your question. There have genuinely been probably more than I've seen in any webinar that we've done. So obviously it's a popular topic and very common out there. Before we jump into the questions, though, we'll just take a quick step back and go through the poll that we ran at the beginning. So to those of you that were late in joining, we ran a poll in the beginning asking 5 or 6 questions. There were a few that stuck out, and obviously we're a little bit time constrained here. So just a few things that really did stand out. There was a question there around in the past 12 months, have you experienced or been threatened with an unfair dismissal or GP claim? 95% of you that answered had either had a claim, a threat, or are seriously concerned that it could happen. Over half of you have had a claim lodged, which is a fairly alarming stat. I was genuinely surprised about that.
There was proves my point, though, Mark, doesn't it, around barrier to entry? It's a very, very low barrier to entry. You've all experienced it, and you've all experienced the stress.
Yeah, exactly. And nearly a quarter of them were threatened but not lodged. So that again goes on what you said there. There was a question there that we asked around the consistency of your performance management and termination documentation. Over a quarter of attendees experience issues with inconsistency and inadequate documentation with dealing with termination and performance management. Like you said, Ian, paper beats opinion. And again, we'll jump into how we might be able to assist with that. Absolutely, it's something that we can help with. But again, over a quarter of the people that have attended today have said that, they do experience issues around inconsistencies.
Yeah. It might, Mark, sorry, before you go on, it might just be worth, so when I talk about documentation, and I think that can conjure up these ideas of having to write screeds of words and that it has to be a verbatim response or a verbatim record of what's occurred. It doesn't have to be. It can be dot points. It really can. It can be literally on a post-it note, though I don't recommend that. There was a discussion at the time it occurred, who was in the room, what was the basis of it, what was the feedback that was given, how did they respond? And it can be dot pointed. That's absolutely fine, and it can take 3 minutes. It doesn't have to take half an hour.
Exactly. And just the other one I'll touch on very briefly was the asking of how familiar people were with Small Business Fair Dismissal Code and how it applies to your business. Nearly half of the respondents are either completely unfamiliar or not confident in understanding how that applies to their business. Which again, that's a significant response. And then just to finish off, we've got a couple of minutes. We'll be able to get through a few of our questions and then we'll finish things up. All right. All of this is going to be sent out to you guys after the session's finished as well. Just wary of time, Ian, we'll go through a couple of questions. And this, like I said before, this has been probably the most interactive session that at least I've hosted in my time here. Tons of questions. Just a couple of them. What are the most common mistakes that you see businesses make that lead to something like an unfair dismissal or a general protections claim?
Yeah, it's that conversation again. It's around the documentation point is all about the defence of it once it happens, so you're able to defend yourself. The thing that leads to the claim is that the and mind you, because of the low barrier to entry, this is by no means a guarantee that it's going to prevent a claim from occurring. But an employee who doesn't feel that they've been listened to, or that they have been treated unfairly because the issues that were put in front of them either weren't put in front of them regularly or within time for them to be able to improve, or they weren't given the opportunity to respond to them, is going to leave them feeling that they've been unfairly treated, and they're going to look elsewhere. If you're terminating their employment, you're giving them 4 weeks' notice under the contract, and that's all they get, plus their holiday entitlements, etc., their statutory entitlements, they're going to feel pretty aggrieved in that scenario. In circumstances where you've had conversations with them, you've talked to them about it, you've almost got them to agree that their performance has been substandard, but they feel listened to, they're far less likely to bring a claim in that scenario. It's not off the table because, again, they can just lodge one and AI, ChatGPT can help them do it. But they're going to be far less motivated to do it if they feel that they've been listened to and they feel that they actually understand the basis upon which the criticism or the performance management has occurred.
Right. Okay. This one kind of applies as well to one of the polling questions a little bit, but what's the biggest red flag that tells you a termination is actually likely to turn into a claim?
The slamming of the door as they walk out the room is always a good one. But it's the I think there's two. One is your own analysis of how the performance management process or the process occurred or went. I think you get a sense of it that probably they're pretty disgruntled. I wouldn't be surprised if something occurs as a result of that. And again, it's going to be the red flag's going to be whether they've resisted, whether you've given them the opportunity to or whether you've had the opportunity to have the discussion and really give them your side of the story in a safe environment. The red flag is what their attitude is, whether they have just clammed up altogether, or whether they've aggressively responded. Generally is going to be the flag that something's going to happen. You can't do much in that scenario to prevent it from happening other than, and this is not a recommendation and it's a case by case thing, but there are ways obviously of preventing it by saying, but look, you're entitled to 4 weeks, but we'll give you 5 and here's a deed of release. You can do that too. And that will prevent the claim from obviously occurring, but it comes at a cost. But you've just got to weigh that up. And that's not a general recommendation. It's a tool that we've got that we can look at, but it's a particular circumstance thing. And I'm definitely not recommending that as how you deal with these issues.
Absolutely. We'll do one more before we just finish up on the last slide. When an employee is in probation, what's the responsibility for providing feedback and how robust do you have to be now?
Yeah, I think for me, and this is perhaps idealistic, but it comes down to how would you like to be treated in probation? And that's what you should be doing. So thinking in terms of obligation, think about the role that person's playing and whether they're doing it well enough and how you can help them do it better. That's the feedback level that'd be the test that I would apply effectively. If they're in probation, and it's usually 3-6 months, generally you've got that minimum employment period, which I talked about before, where you can terminate them in that period and they're not going to be able to bring an unfair dismissal action against you. So you don't have to be as fair during that first part, but you employ people not because you're going to terminate them, you employ them because you want them to do a really good job. So I'm a big one as a manager myself. I'm a big one for a lot of interaction, a lot of contact, and a lot of constructive feedback, and opportunities for them to ask questions and for them to give feedback on how they've gone. There's no one way of doing that. It's going to depend on the job and it's going to depend on how busy everybody is. But if you have a 6-month notice period and the manager has not met with that new person at all in that period, that's going to be a big red flag.
Correct. All right. Well, I think that brings us to the end. Sorry, guys, by the way, we obviously haven't got to get through everybody's questions. There's heaps more there. We could be sitting here for another hour or so. So thank you all for joining. As I mentioned at the beginning of today's presentation, we'll be sending a follow-up email later on today, which includes a link to the recording. So you're welcome to share this around with anyone else internally there. As always, any questions you've got, you can reach out to myself, to Ian, to his team. You'll have my details shortly. I think it might pop up on the screen. Next slide, potentially. There we go. So our details are there. Please do reach out. Thanks everyone for joining, and yeah, we'll be in contact with you soon, hopefully. Cheers. And
Thanks,
thank you,
everyone.
Ben.